attend today. For the record, I am the Professional Standards Division Director, Kathy McAlpine. And I'm going to go ahead and read our administrative announcement first. This is a public meeting, subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by applicant review committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. And staff, you call a roll call?
I think we can go around the room and then I can do online if that works.
That works.
Perfect. So we'll start with you and go around.
Okay, again for the record, acting as chair, Deputy Director of Professional Standards, Captain McAlpine, for DPSSD.
Okay, we'll go my direction.
Yeah.
This is Jennifer Howell, DPSSD Legislative Administrative Rules Coordinator.
Alex Gardner, OSP Command Staff and Police Policy.
Aaron Reyes, Superintendent, Oregon Department of Corrections, Umatilla.
Shelby Wright, Executive Assistant, DPSSD.
Samantha Cosa, Executive Support, DPSSD.
Erica Dell, Criminal Justice Specialist, DPSSD.
Cindy Park, Professional Standards Compliance Coordinator for DPSSD.
Melissa Langacho, DPSST Professional Standards Case Coordinator.
And Jennifer Lavario, DPSSD Special Standards Compliance Coordinator.
And those on the line, Chelsea?
Kelsey Labar, representing telecommunications.
And then Member Langley.
Captain Langley, representing the Oregon Sheriff's Jail Command Council.
Okay, thank you. I'll turn it over now to Cindy Park.
Meeting minutes.
See, you give me a script if I don't follow it. Okay. First order of business is if everybody's had a chance to review the October 25th, 2023 meeting minutes. If so, are there any discussions or can I get approval?
Alex Gardner, for the record, I move approval.
And they have a second.
Aaron Reyes, I second.
All right, we are voting on a motion to approve the October 25th, 2023 meeting minutes. Committee Member Gardner.
Aye.
Committee Member Labar.
Aye.
Committee Member Langley.
Aye.
And Committee Member Reyes.
Aye.
Motion passed.
Okay, now we will turn it over to Case Manager Cindy Park.
Is there an officer in order?
I can go get them.
Okay.
Are we starting with Olhausen?
That'd be great.
Yep.
Ms. Rollhouse, if you go ahead and have a spot right at the speaker portion of this.
Thank you.
Just for your edification, the compliance investigator will kind of review this, and then we'll turn it over to you to have, and I'll talk to you about what the procedure is for you to speak after that.
Okay, excellent, thank you.
You're welcome.
Cindy Park for the record. Meeting regarding Officer Derek Olhausen, who works for the Oregon State University Public Safety. He was hired November 13th in 2013 and is scheduled to attend basic police class 437 starting January 29th, so on Monday. On February 25th, 2016 in Albany, Oregon, Olhausen was charged with 1 count of reckless driving and 5 counts of reckless endangering after a vehicle he was driving with 5 passengers crashed into a structure causing damage. A passenger in the vehicle admitted they had been drinking alcohol. On June 28, 2016, Olhausen entered a no contest plea to reckless driving and 1 count of reckless endangering. The remainder of the charges were dismissed. He was sentenced to a 2-year unsupervised probation, 90 days of jail suspended, and a payment of fines and fees. Moral fitness violations. The department did not identify any elements of dishonesty. Gross misconduct. Olhausen engaged in misconduct by recklessly driving and crashing into a house, which created substantial risk of serious physical injury to himself and his passengers and caused damage to the property of another. Olhausen was not employed in a certifiable position at the time of the conduct, and Olhausen was hired by Oregon State University Public Safety, who was aware of the criminal disposition. The department submits its determinations to the policy committee to affirm, modify, or negate these moral fitness violations.
Thank you. All right, Mr. Olhausen, you now have 5 minutes to give your testimony. The staff will have a timer there for you. It won't start until you start.
Okay.
And so the floor is all yours.
All right, thank you. As I'm sure you've all been made aware, my name is Darryl Olhausen. I was offered a job as a police officer for Oregon State University's Department of Public Safety and accepted that offer. I started working for the department November 13th of 2023. I'm currently scheduled to attend classes here at DPSST starting January 29th of 24. We're here today because of a mistake I made involving reckless conduct approximately 8 years ago now. I decided to speed in my car down an unfamiliar road in a residential, which intersected at the end, and I was going too fast to make the turn. This resulted in me damaging private property that exceeded over $10,000 in damages. Later, my mother drove me to the victim's house because I wanted to formally apologize. I wasn't able to at the time, as you could imagine, due to separated parties. Not to mention he was pretty upset, as I would be now owning my own home and having my own family. I was emotional because I'd found out that he had 3 children and his wife on the property, and I couldn't help but think what my actions could have resulted in if we hadn't been as lucky. Really dumb, not thought out decision could have resulted in the loss of life or in causing great bodily harm. I own this now. I decided to tell myself that this incident was a learning experience, and if anything, it has made me a more cautious driver ever since. I look forward to being able to use this experience to educate and relate to the public throughout my career, starting with the students at OSU. The 2 friends that were also in the car with me at the time that ran from the scene proved to me that they no longer deserve my friendship, and I haven't associated with them since, also a valuable lesson. I took a guilty plea because I knew my actions resulted in an accident involving a motor vehicle striking a house that could have injured or killed someone that night. I've owned my mistake and moved on. Since then, I've had no negative encounters of a criminal nature with law enforcement. In law enforcement, there will be times I'm required to break the traffic laws in the capacity of my duties. While doing so, I will need to be conscious of the limit of my abilities, also of everyone and everything around me. Prior to my hiring at OSU, I worked approximately 2.5 years as a sworn limited duty corrections deputy at the Benton County Jail, averaging about 20 hours a week, while also working a salaried full-time job for Solid Ledge Island Farms Incorporated as a field scout. This involved me having a take-home company truck and driving up and down the valley Monday through Friday. In summary, I ask you, as a review committee, to not judge me by my past, but to also, as I do, look towards my future and the many lives that I hope and plan to positively impact during my career in law enforcement and service to the people of Oregon. Thanks.
Thank you, Mr. Olhausen. Now we'll open it up for discussion, and discussion could include identifying any aggravating and mitigating factors.
Alex Gardner for the record. It's been a while since I've read this. Am I remembering correctly that it was actually a no contest plea?
Well, my record showed that it was a no contest plea. Is that correct?
That is correct.
So I'll just continue and say for the record that generally speaking, a no contest plea is not the first step in accepting responsibility. No contest plea means I'm not admitting it, but you can prove it. I believe you can prove it. I'll just say what I'm uncomfortable with, among other things, is the fact that there was drinking involved, and I may remember this incorrectly again. It's been a while since I've read it. I didn't remember him being encountered by law enforcement at the scene. I thought he had left also. Did he not leave the scene?
In reading the records, I believe that he had left the scene.
I had not left the scene. I was the one that remained on scene. My two friends left the scene, and there were some miscommunications with the homeowner thought that one of my friends that was wearing a black hooded sweatshirt that had the hoodie up, that ran from the scene, he repeatedly told the officers that he was the driver. It was my car, and I repeatedly told them that it was me driving. I stayed there, and I think because of that reason.
I'm going to just interrupt you just for a moment. Again, you're here just to give your statement, but we're not here to depose you or engage in a conversation with you. Any of the panel members or committee members can seek clarification from the case manager, but I just want to let you know, just stop it here because that's not the process. So, but thank you.
And the police report was fairly limited. What we were able to access was not an extensive police report. So there is that information, and then we pulled out what we could from it.
Okay.
Ted Langley, for the record, my recollection of the information we were provided is that it indicated that he actually did stay on scene.
Chelsea LeBar, for the record. I too, that was my takeaway from the documents provided. Mitigating factors, this was almost 8 years ago, and I believe he was 23 at the time, would now be in his 30s, and I do think I'm a very different person than I was in my early 20s. So I think 8 years is a substantial amount of time. Remaining on scene, another mitigating factor for me, but then the aggravating is the attempt to hide beer in the trunk after crashing the vehicle. And then I'm a little bit concerned about today about accepting responsibility but pleading no contest.
Thank you. Is there any further discussion? If not, then I'll call for a motion to adopt the staff report.
Alex Gardner, for the record, so moved.
You want a second?
Aaron Reyes, I second.
Chelsea.
All right, we are voting on a motion to adopt the staff report. Committee Member Gardner?
Aye.
Committee Member LeVar?
Aye.
Committee Member Langley?
Aye.
And Committee Member Reyes?
Aye.
Motion passed.
Is there any further discussion? Seeing none, we call for a motion to take action or no action.
Alex Gardner, for the record, I move that we take no action.
Do I have a second?
Chelsea LeBar, second.
All right, we are voting on a motion to take no action. Chair Gardner, Committee Member Gardner.
Aye.
Committee Member LeVar.
Aye.
Committee Member Langley.
Aye.
And Committee Member Reyes.
Aye.
Motion passed.
Okay. Thank you, Mr. Hall. You can be excused now.
Thank you all.
Appreciate it.
You can just go this door.
Thank you. And damn. Cold and damn.
Yeah.
Oh. Is our police department oversee all this?
No.
Who's next? Sarah, can you know,
we
person?
can do that.
Long as it's not.
Did that up about, I want to say about 3 years ago.
Okay, found that one. That was back when it was exec security.
I think the last one of our exec security people was Ted Phillips, I think. He was our last one.
Yeah, Kathy, he would be, no, Scott Salisbury retired too. It was in my class.
Ted retired almost exactly a year ago, maybe a year and a month ago.
All right, Mr. Purdue, we'll have a seat here, and as we begin opening, just as a reminder, you'll later on, you'll have the time to make a statement, but we will not engage in a conversation in that. Okay, so this is the second case, Sean Purdue. Cindy, you want to go ahead?
Cindy Park for the record. We're meeting regarding Corrections Officer Sean Purdue, who works for the Department of Corrections, Snake River Correctional Institution. He was hired May 1st, 2023 at Snake River, and he was before the committee for a 2019 criminal disposition. On October 30th, 2018, a victim who was a relative of Purdue made a report to Fruitland, Idaho Police Department stating Purdue had broken into their residence and stolen cash on October 29th. The victim stated this had been an ongoing issue. Purdue was observed by a neighbor as well as a surveillance camera driving up to the residence, going through a gate. Purdue did not have keys to the residence and been told not to enter the residence unless somebody was at home. Purdue admitted to entering the house without permission and stated he gained entry through a dog door. Purdue was initially charged with unlawful entry, burglary, and theft, petty theft. The burglary charge was dismissed, and on March 26, 2019, Purdue pled guilty to unlawful entry and theft, petty theft. He was sentenced to 24 months supervised probation, 10 days work detail, 365 days jail with 345 suspended, as well as fines and fees. Moral fitness violations, dishonesty. Purdue repeatedly entered the home of a family member without permission after being told specifically he was not to go into the home alone and took money not belonging to him. Purdue was dishonest with the Fruitland police officer when he initially denied entering the victim's home because the doors were locked. He later admitted he had gained entry to the victim's home via the dog door. The department did not identify any elements of gross misconduct. Purdue was not employed in a certifiable position at the time of the conduct. Purdue was hired by ODOC SRCI, who was aware of the criminal background. The department submits its determinations to the policy committee to affirm, modify, or negate these moral fitness violations.
All right, thank you. Mr. Purdue, you will have 5 minutes to make any of your statements, and the timer will start when you begin.
Thank you for allowing me to speak today. My mother-in-law, who is involved in the incident, is here for my support. My wife, who would like to be here, couldn't do so due to work. My name is Sean Purdue, and I'm here today to shine some light on the things that I've done to try to better my life and the changes that I've made since then. Most people would go back and correct the mistakes that they've made, given the opportunity, and me as well. Therapy had helped me realize all that we can do is move forward with remorse and what we have done and work to become a better person. The poor choice that I made will be with me for the rest of my life, along with the guilt of what I've done. Guilt's a powerful emotion, and it never really leaves you. You just learn to live with it. When I got into trouble, I did end up confessing my wrongdoings and stood on trial in front of my family and was judged and sentenced. To know you did something that will never go away, to hurt the people that you love the most, and to disappoint your family and your parents, lose your friends that you've known your whole life is the worst feeling in the world. There isn't a day that goes by that I don't feel bad and regret for what I've done. But since then, going to counseling for impulse behavior and realized how selfish my ways were and only thinking about myself and not seeing the damage I was causing to others. I live my life now for my wife and my 2 daughters. I want them to grow up and be proud of their father and I know that they'll find out about what I did one day, and I will own up to it again, and it will hurt all over, and I'll explain to them that I'm not perfect and I did all that I could to make amends after the fact to those that I wronged. Over the years, I have had various sales and consulting jobs, and none of them have worked out. My mother-in-law, who's here with me today, had asked me if I'd ever thought about working at SRCI, and I have some friends there, and I really didn't think it was for me, but I applied because I wanted to make my life better. And I was happy after everything had worked out. I was accepted and went through the training academy, and going through BCC was a life changer for me and showed me that I could really make a difference in other people's lives. From helping my teammates with computer work, practice defense tactics, working on de-escalating with verbals and communicating in a pro-social manner. My consulting background had provided very helpful in speaking with AICs once I was inside for work. I've gained a lot of respect for those that I work with, and I enjoy going to work, and I love the fact that we get to try to help people better their lives from where they've come. I hope that I'll be lucky enough to call myself an officer one day, and I thank you for your time.
Thank you, Mr. Booth. I'll go ahead and open it up for discussion. Again, discussion should include identifying aggravating and mitigating factors.
Aaron Rice for the record. There's a concern I have is repeatedly enter the residence admitted to doing so, which shows knowingly with intent to commit a crime.
Alex Gardner for the record. This conduct amounts to a series of Bird 1s in Oregon, and Bird 1s are Class A felonies, so each of those incidents is punishable in theory by up to 20 years in custody. And I do appreciate that he owned it eventually, but he lied actually initially. And people who own their misconduct after lying and sort of being caught, the owning it is worth less. It's less of a mitigation. I'll just say, for me, this is very difficult because it seems like a very sincere apology, but after being in this general line of work for a very long time, it's very hard for me to wrap my brain around somebody being in any kind of law enforcement capacity after involving themselves in this kind of conduct. So I have a question for staff. This isn't directly related to this disposition, but what is in the event that this group takes action, what is his recourse downstream? Is there an appeals process? Is there a second look?
We file a notice of intent, and they have a period of time to request a hearing regarding this matter.
And in front of whom would the hearing be?
In front of administrative law judge.
Okay, thank you.
Aaron Rice for the record. Concern of not being truthful with the police officer from Fruitland, which goes against the code of conduct for the Oregon Department of Corrections, and in the position that he would be certified for would be given statements to law enforcement officers regarding AIC and/or staff behavior and conduct.
Any further discussions? If nothing further, I'll call for a motion to adopt the staff report.
Alex Gardner, for the record, so moved.
Aaron Race, I second.
Any further discussion? Hearing none, I will call for a motion to either take action or no action.
Alex Gardner, for the record, I move you take action.
Aaron Race, I'll second it.
Ted Langley, for the record, I would second that.
Okay, we have a first and a second. Roll.
We have to do the adopting the second.
I jumped the gun again. My apologies. For the record, I will go back to the step of adopting staff report. We did have a first and second motion. And if I can have a roll call, please.
We are voting on a motion to adopt the staff report. Committee Member Gardner.
Aye.
Committee Member LeVar.
Aye.
Committee Member Langley.
Aye.
And Committee Member Reyes.
Aye.
Okay, and then we did take a motion and a second. We're able to capture both of those.
I did get a second. Is that
We
Aaron?
both, yeah, we had two kind of at the same time.
Okay, so we are voting on a motion to take action. Committee Member Gardner.
Aye.
Committee Member LeVar.
Aye.
Committee Member Langley.
Aye.
And Committee Member Reyes.
Aye.
Motion passed.
Okay, the motion is to take action, and I'll now call for a discussion regarding the amount of ineligibility period. How many?
Up to 10.
Yeah, up to 10 years is the consideration.
Alex Gardner, for the record, does the eligibility period start the incident date?
Starts with the date of the disposition. So it would be, and my notes, from March 26, 2019.
Ted Langley, for the record. Sorry, the audio broke up just a little bit online, but did you say that that would start from the date of disposition, and that was March of 2019?
Yes.
Alex Gardner, for the record, I move a 5-year period.
Okay, and the first motion include why the specific timeline recommended?
Normally, lying and felonious misconduct like this would merit a very long period of suspension. In my view, that would be 10 years in this case. But he seems contrite and he has family support, and I'm hopeful. Trying to give him a break in recognition that people do change.
Thank you. And do I have a second?
Chelsea Labari, second.
All right, we are voting on a motion for a 5-year ineligibility period. Committee Member Gardner.
Aye.
Committee Member LeVar.
Aye.
Committee Member Langley.
Aye.
And Committee Member Reyes.
Aye.
Motion passed.
Okay. Thank you, Mr. Purdue. Excuse now.
Thank you.
I missed it. Timing, I missed it. Plowing ahead. It's another reason I shouldn't be chair of anything. in my head, I'm saying, I would never gamble I often say that on this committee, I would not gamble on this person, we can't afford to gamble on this person. I appreciate that somebody else has had a harder look at the person than we get. I don't know how thorough DOC backgrounds are.
That's an off the record story.
Okay.
And you are.
We're being recorded.
Copy that.
Good morning, Mr. Riley. Okay, this will be, our next one up is a review of Christopher Raley. Let's see.
We're reviewing the case for Deputy Christopher Raley, who works for the Klamath County Sheriff's Office. He was hired by the Sheriff's Office on November 1st, 2023, and is also scheduled to attend Basic Police Course 437 on January 29th, 2024. Reviewing a previous criminal disposition on April 15th, 2021, Raley was involved in a single vehicle collision in Johnston County, North Carolina. A North Carolina Highway Patrol trooper responded. Raley initially stated he had not consumed alcohol, rather he had fallen asleep while driving. Raley later admitted to the trooper he had consumed alcohol and should not have been driving. Raley was ultimately charged with the offense of driving while impaired. On January 11, 2022, Raley pled guilty to the offense of impaired driving and was given a 12 months unsupervised probation, 60 days in jail suspended, and was required to complete 24 hours of community service. Moral fitness violations, dishonesty. Raley initially stated to the North Carolina Highway Patrol trooper he had not consumed any alcohol but had fallen asleep at the wheel, resulting in a single vehicle accident. Raley later admitted to consuming 2 beers and admitted he should not have been driving. Gross misconduct. Raley's reckless conduct of driving while under the influence of alcohol caused harm to his vehicle and could have caused significant harm to others traveling along a public roadway. Raley was not employed in a certifiable position at the time of the conduct. Raley was hired by the Klamath County Sheriff's Office, who was aware of the previous criminal disposition. The department submits its determination to the Policy Committee to affirm, modify, or negate these moral fitness violations. Kathy.
Okay, Ms. Raley, you will now have 5 minutes to provide us any information you'd like the committee to review. It's not a dialogue, we won't be asking you questions or clarifying, and the timer will start when you begin.
As you all are aware, on April 15, 2021, I was involved in a single vehicular accident that resulted in a DWI conviction. State trooper arrived on scene minutes after the accident happened and found me pacing back and forth as I was trying to figure out what steps to take, as I had never been in an accident before that. The trooper asked me if I was leaving the scene. I replied no. I rated myself a 9 out of 10 due to the fact that I had just wrecked my car and had fallen asleep and knew I shouldn't have been driving. I had a lapse of judgment this night, and I endured consequences legally and personally. In the Marine Corps, I was demoted from sergeant to corporal and had 2 months I had pay, along with doing everything else that they're required of me. There isn't a single day that's gone by where I haven't thought about the mistake that I've made and the consequences I could have faced. This night, I could have not only ended my life, I could have ended the life of other families. I have 2 children of my own, and I couldn't imagine losing them to someone who made the same mistake that I chose to do. From the moment I made this mistake, I've taken any chance I could to own up to it and help others learn. I was transferred from a recruiting command that I was working at during the time of the incident to another aviation unit, where I became a mentor of many other junior Marines, and I've done my best to prevent them from making the same mistakes, because junior Marines like to drink. My supervisors from my last command said that they would have never guessed that I had left a command before that with a DUI conviction. I've been working with the Klamath County Sheriff's Office since November 1st, 2023, where I made a point before I was hired to make it clear that I had a criminal history of the DWI. Working at the Klamath County Sheriff's Department has taught me that I've had a constant reminder of what could have happened to me as I work DWI crashes all the time. I have served honorably in the Marine Corps for 9 years and 1 month. I'm asking for the opportunity to continue to serve the residents of Klamath County and prove that this single but devastating lapse of judgment does not define my character and the person I've worked so hard to become. Thank you.
Thank you, Mr. Rayleigh. Again, I'll open it up for discussion. Discussion should include identifying aggravating and mitigating factors, and we can have Cindy review those again if need be, that we've identified.
Chelsea LeBar for the record. First, I appreciate that you came to address the committee and talk about this and take some responsibility. In identifying aggravating factors, I do think it's occurred just under 3 years ago, which is not that long ago. But I also, from the documents provided from DPSST, I saw that it was recommended but not a requirement to complete an alcohol and drug assessment, which you voluntarily completed. So I would like to acknowledge that.
Ted Langley for the record. I would agree with the previous sentiment that I'd find mitigating the fact that he complied with the court orders. And I'd also list as mitigating the letter that was supplied from the Klamath County Sheriff. However, I do believe in his letter he miscorrectly identified that in the staff report no dishonesty was found, but the staff report in front of us actually says that there was dishonesty identified in the investigation. So, for what that's worth, for what the contradictions were, either way, I still find value in the fact that the sheriff wrote the letter.
If I might clarify, when I sent out the initial staff report, it did not have an element of dishonesty. It was after it was reviewed by the director that we added that into the draft staff report. So when Sheriff Haber received the letter, it did not have an element of dishonesty in it.
Ted Langley for the record. Thank you for that clarification.
Alex Gardner for the record. I saw the dishonesty element. Anybody who's been a cop for any length of time knows that everybody who gets stopped for DUI has had 2 beers. If they own it, they've all had 2 beers, it seems, no matter how drunk. And so, to be frank, I expect a certain amount of fogginess, and I don't expect much clarity out of people who are intoxicated. So this is not the sort of dishonesty that we saw in the other case we heard this morning. So I discount that. And the mitigation is, for me, is that he wasn't in a law enforcement position at the time, and he was serving his country. Although this was an embarrassment for the Corps, it sounds like he made good on that.
Okay, any further discussion? If not, seeing any, I'll call for a motion to adopt the staff report.
Aaron Rice, I move to adopt the staff report.
Alex Gardner, second.
All right, we are voting on a motion to adopt the staff report. Committee Member Gardner?
Aye.
Committee Member LeVar?
Aye.
Committee Member Langley?
Aye.
And Committee Member Reyes?
Aye.
Motion passed.
Okay, is there any further discussion? Seeing none, then I'll call for a motion to either take action or no action.
Aaron Rice, I move we take no action.
Alex Gardner, second.
Okay, we have a first and second. Nicole?
All right, we're voting on a motion to take no action. Committee Member Gardner?
Aye.
Committee Member LeVar?
Aye.
Committee Member Langley?
Aye.
And Committee Member Reyes?
Aye.
Motion passed.
Okay, thank you, Ms. Rayleigh. You can be excused.
We'll head you out this door. Okay.
Ms. Chair.
See you.
Okay, we will move on to inquiry closing memos.
All right. 1 second. Cindy Park for the record. DPSST has enclosed the following inquiries into pre-employment criminal conduct as detailed in the attached inquiry enclosure memos. These documents are provided to the committee for informational purposes, as Oregon administrative rule has given DPSST the authority to close these inquiries without committee approval. And there are numerous reports this month.
Okay, is there any discussion on this section? Did you vote?
No, I'm sorry. So this is the.
This is the provisional, that's what, okay.
Right.
I believe so.
Okay, there,
There's,
back checking myself here.
there's no vote.
Okay, if there is no further business, our next application review committee meeting will be February 28th at 10 a.m.